In many states, there are court cases seeking to have Donald Trump disqualified for running for president for having violated Section 3 of the 14th Amendment that says that anyone who is an officer of the United States who took an oath to the Constitution and who then engaged in an insurrection is disqualified from federal office. There are cases all over the country, most notably in Colorado, trial just happened, in Minnesota, where the Minnesota Supreme Court just ruled, and in Michigan and other states, there are cases pending. In Minnesota recently, the court dismissed the case, saying it wasn't ripe, meaning that Donald Trump was only running in the primary for president, and that was only to choose delegates. And so it wasn't actually establishing whether or not he would be president. That political parties have wide leeway, as they do, to select their nominees. The challenge with bringing these cases right now, whether they're right or wrong, and certainly the legal claims have significant strength to them, is that it's going to be difficult to have this resolved by the Supreme Court in time for the 2024 election. The nominee of each party won't be selected until midsummer of next year. And by that time, the Supreme Court will have already adjourned for the summer, not to come back into session until early October. In order to get these cases heard and then work their way through the system up to the United States Supreme Court, which they'll need to do in advance of the election, is going to be really challenging, particularly because ballots for the general election are going to start being printed in August. So the time between the conventions and when ballots are going to be printed is very short. We should keep a close eye on this. Perhaps a court will rule otherwise and start the process of getting this up to the Supreme Court. But it's one of the procedural challenges that we'll see in the efforts to disqualify Mr. Trump from the ballot.